Hola, buenos días, bienvenidas y bienvenidos a esta última mesa del conversatorio sobre el test de proporcionalidad. Les agradecemos muchísimo a todas las personas que nos han acompañado a lo largo de esta semana y media en cada una de las sesiones a las que hayan podido asistir. Y para clausurar esta semana y media de trabajos y de reflexión sobre el test de proporcionalidad, los dejo con la directora del Centro de Estudios Constitucionales de la Suprema Corte, la doctora Ana María Ibarra Orguín. Ana María, muchas gracias.
Muchas gracias, Diana, a ti por pues haber convocado este gran conversatorio. Creo que es por lo primero que me gustaría iniciar, ¿no? Por darte las gracias, Diana González, investigadora del Centro de Estudios Constitucionales, por esta espléndida organización, convocatoria y trabajos a lo largo pues, de esta semana y media. También quiero agradecer muchísimo a Diana Suárez, otra de nuestras Dianas del Centro de Estudios Constitucionales, quien la verdad pues también ha estado detrás de cámaras todo este tiempo, pero que ha sido pues una parte fundamental en que todo haya salido espléndidamente. Y pues al equipo técnico también de la Suprema Corte, de verdad hacen un trabajo fenomenal. Nosotros nada más venimos acá y nos sentamos a conversar con todos ustedes, pero pues sí hay muchísimo trabajo detrás, ¿no? De todas y cada una de estas conferencias. Y pues también platicábamos que estamos, la verdad, muy emocionadas por los grandes resultados de este conversatorio, no solo por la calidad de cada uno de los ponentes que fueron tan amables de regalarnos su tiempo y tan generosos de contestar cada una de las preguntas que planteó el público. De verdad, pues todos ellos son magníficos y hoy tendremos también a dos grandes académicos para cerrar este evento. Y pues estoy de verdad muy emocionada porque cuando nosotros iniciamos esta línea...
Because when we started this line of investigation of proportionality test in the Supreme Court, when we started, it would seem something like very theoretical and away, very far away from the Mexican reality because of the complexities of the Mexican reality. We thought that perhaps there would be just a couple of people that would be interested in these topics, and we thought that maybe we would have no incidence on the others, but 2.5 years have gone by after the first Congress, and it is clear to me that things have been totally different. Actually, the test of proportionality is permeating really into the judicature. We can see it because of the interest that you'll have on the training courses, on the diploma courses, also on the downloads of the books that we published on this topic. And this can also be seen in the almost 20,000 people that we have as audience in this event. So this is something that is truly unthinkable, and it is great to see it. And during the reflections of the past days, what has been clear is that there could be many objections to this methodology, but this methodology is indeed a useful tool for the judicial activities. So this is really wonderful to be able to have a lot of speakers. And something that I would like to underscore, besides the fact that technology helps us break distance, not just with speakers, but also with the audience, that they can watch us from everywhere. Anyone can listen from everywhere. That really helps a lot. And also the Supreme Court opened up this platform to try to bring English speakers also to this seminar, that otherwise we would never have been able to join them or to bring them to Latin America, for example. You know, this approach has been really critical, and this exercise has been fantastic. This is why I would also like to I would like to thank the interpreters that we have for the last week and a half. The interpreters have done an excellent job. I listened to them in Spanish, and they actually do a great translation in these technical topics. So thanks to the interpreters as well for doing such a good job. And I would also like to thank all the participants that have joined us in this last week and a half. We're so happy for them having joined us in this event. And we would like to tell you that most presentations will be published in the YouTube channel of the Constitutional Studies Center. So we will be able to continue to disseminate these ideas, these conversations, and you will also have access to them on the YouTube channel. And this is what this is all about, to try to bring the academia to citizens, to the judicature in Mexico. I think that the Supreme Court is really doing a good job. And I would like to thank the President of the Supreme Court of Mexico for giving us this space and these possibilities. So I took a lot of time already, but I would like to give the floor to Diana. Diana, we will really close with a high note this session. Thank you, Ana Maria. And to close with a very, very high note, this seminar, we have this last table. This last table that is made up by Jude Mathews, that is professor at the School of Law of Penn State. And he will talk to us about proportionality and the unanswered questions. So he will be having this talk and to answer those questions. And then we will listen to Juan Pablo Uribe Barrera. He is professor at the university also of his city, and he will also pose a question: when, if there are any, when, if any, could we implement this without going against the constitutional rights? So with this wonderful table, I will leave you. Thank you very much for taking the invitation. Professor Mathews, I'll give you the microphone.
Thank you so much. It's a great honor and a pleasure to be with you today. I'd ask that if I end up speaking too quickly for the simultaneous translation, if someone could please make a note to that effect, and I'll try to do better. But I'm honored to be able to have the chance to speak with you today, in spite of the distances between us physically. And my topic is, or my title is, Proportionality, Unanswered Questions. These are questions that are unanswered, at least by me, or so far as I know, by others as well. I'm going to make my way towards these questions, but somewhat slowly. In fact, the bulk of my talk is going to be getting to the questions by reflecting on the conversations scholars have been having about proportionality over the last 15 years or so. And as I kind of give you an overview of how I understand these conversations, I do so without any claim to being comprehensive or definitive. But what I want to do is to differentiate between some of the different kinds of very productive conversations that have been happening about proportionality over the last several years. Conversations playing out among different constituencies with different perspectives and different questions that are of particular importance to them. But in my view, topics that come up in these different conversations together point towards a set of questions that are interesting me for the years ahead with proportionality. From the very beginning, scholars have been drawn to proportionality for different reasons and have come to it from different scholarly disciplines. I'm going to sort these conversations about proportionality into three broad categories. As a shorthand for each, I'm going to describe them as a philosophical, doctrinal, and political discussions about proportionality. As I'm going to describe, these different divisions are not only not watertight, but what happens in one necessarily matters to what happens in the other conversations. In other words, people involved in these different conversations around proportionality, I think would do well to pay attention also to what's happening in other conversations. And perhaps more attention should be paid across these boundaries than has been to this point. I want to start with the philosophical or theoretical conversations around proportionality. From very early on, many of the scholarly debates about proportionality concerned its normative justification. Why should rights claims be adjudicated by means of a structured balancing framework as opposed to, say, a different approach, one that relies more on categories or rules? This question has engaged titans, not only of legal theory, but also of philosophy. And these have included, of course, from early on, Robert Alexy and Jürgen Habermas. But the conversations have continued. Normative debates about proportionality. In more recent years, they have involved, among many others, Matthias Klatt, who spoke earlier as part of this conference, and Moritz Meister, Kai Müller, Jacob Weinrib. And on the other side, people expressing more skepticism about the normative appropriateness of proportionality. We have figures including Stavros Tsakirakis, Gregoire Weber, and Francisco Urbinas, among many others. There have been many strands too, and discussions within this scholarship. Some strongly analytic in quality, aimed at conceptualizing the proportionality test, structuring it so as to align with the normative claims made on behalf of proportionality. Obviously, these efforts to theoretically reconstruct the proportionality framework are closely connected to doctrinal scholarship about what courts do or should do when they undertake proportionality. Some of the more theoretical discussions have tended in the direction of political theory, asking why, in a democracy, it's appropriate for a court to decide matters of great public import on the basis of a weighing of competing principles, interests, or values. Some of the conversations, debates have been still more abstractly philosophical about what it means for a decision to be rationally justified, and whether a decision reached by weighing competing principles, values, or interests can meet that standard. Obviously, there's connection between these different debates. In particular, the question of the justification for judges doing proportionality and the question of proportionality's rationality. If proportionality judgments can't be rationally grounded, and if further the assignment of weight involved in the balancing is reducible to something like political commitments, it becomes harder to argue that judges should be doing this in a democracy. I'm going to come back to that point later. So that's one set of discussions and debates. There's also been a tremendous amount of doctrinal work done on proportionality in recent years, on the brass tacks of what courts actually do or should do when they undertake proportionality review. Here too, there's different lines. Some scholarship is very much system internal, written by scholars within a legal system, directed towards an audience also part of that legal system, about what the tests are in a given jurisdiction and how to do them right. There's also been a flowering of comparative work on how proportionality in practice differs in different court systems. Some of this is focused on how tests are differently labeled, structured, enumerated, on how the application of these tests may differ in intensity from one place to another. More recently, there's been some quite interesting quantitative empirical work about proportionality that's comparative, trying to measure in some sense what courts do in different places when they're doing proportionality. Pioneer in this work is Niels Petersen, who wrote extensively about Canada, Germany, and South Africa. More recently, there's the edited volume edited by Krumnitzer, Steiner, and Lang that looks at those 3 jurisdictions, but adds to them Israel, India, and Poland. I just want to highlight a couple of, to me, important, interesting findings that's come out of some of this empirical work, and specifically out of Niels Peterson's work. Niels Peterson's work suggests that courts tend to grow into the use of the full range of proportionality subtests over time. So in Germany, it took many years before the Federal Constitutional Court decided many cases in the final prong of proportionality through balancing or proportionality in the strict sense. Canada, which came to proportionality later, is arguably seems to be following a similar trajectory to one Germany already trod. Another finding out of Niels Peterson's work, looking here specifically at Germany, Peterson finds that when courts do apply the final balancing test in Germany, or rather when Germany's Federal Constitutional Court does so, and specifically when it finds against the constitutionality of a measure, in other words, when it upholds a rights claim and invalidates a statute in the last prong of the analysis, Peterson finds that rather than taking an approach that corresponds to Alexi's law of balancing, where the court kind of weighs one principle against another principle, in fact, what the court there does is has a more structured reasoning that's a bit more confined. And Peterson actually identifies 4 different kinds of arguments that courts, that the German Federal Constitutional Court engages in, rather than resorting to a straight balancing of principles. So broadly, there's that whole category of doctrinal work. And then there's also work in a political or political science vein, work that seeks to understand proportionality in the broader context of trying to understand judicial governance or judicial politics. Being the province mostly of political scientists, this work starts often from the assumption that standard to that field, that courts are one kind of political actor inside political systems that involve other political actors as well, notably executives and legislatures, and tends to assume further that judges and courts, like other political actors, behave strategically in pursuit of interest, however defined, in pursuit of their interests, however those might be defined. A good deal of the work I have done on proportionality, and in particular the work I've done with Alex Stone-Sweet, has been heavily informed by this perspective. The work that we together have done has built on top of the foundation that he laid in his previous work, aimed at understanding dynamics of judicial governance and the construction of judicial power. In that context, proportionality amounted to the answer to a puzzle. How do constitutional courts manage the politically explosive environments in which they have to function? The answer is proportionality. Proportionality provides an argumentation framework that's stable from case to case, but permits courts to take into account specific constellations of the interest at stake in a concrete case, to speak directly to those interests, and to explain with reference to those interests why the winning party prevails in that case at hand. Proportionality, the theory goes, helps courts build legitimacy by showcasing their even-handedness, their understanding of the interests on both sides, and their reasonableness. It also avoids constitutionalizing winners and losers by leaving courts with the flexibility to tailor future outcomes to future facts. And in this way, it can generate buy-in from interest groups, and parties that appear repeatedly before courts, which in turn generates positive feedback loops over time. This enables courts over time to build their credibility, which in turn gives them power to stand up to and rule against political branches when necessary. There are challenges to this political framing of our understanding of proportionality. One is that there are many moving pieces to it. When we think about the place of courts in a political system, it's common to focus on the interbranch dynamics, on the push and pull between different branches of government, courts being reined in or defanged by legislatures or executives, for instance. But there's a broader context as well that's relevant, and broader public perceptions of courts matter too, and matter to the interbranch conflict story. If courts' practices are widely considered legitimate, it makes courts riskier to go after politically for the other branches of government. Now, it should be said that this political perspective is not always welcome in the company of legal theorists and doctrinalists, and especially from the perspective of judges. Political scientists can sometimes feel like the skunk at the picnic. Judges in particular, at least in the United States, tend to insist that they don't behave strategically, that their rulings are driven solely by their understanding of what the law requires. Also, legal scholars in heavily doctrinal traditions often seem to be skeptical of talk of politics as being, at the very least, something for other people to do, not to be done in the company of legal scholars. But in fact, at least research based in the United States strongly suggests that courts do in fact care about how their rulings are received. And the effectiveness of constitutional courts over the long haul certainly depends on their public acceptance. So looping back, what I'd like to do is to come to how these different perspectives that I've very briefly sketched on proportionality point me towards some questions that I think could be important in the years to come. And I'd like to step back to debates that happen in the theoretical realm. Again, a charge levied against proportionality by some of its critics is that decisions reached through the balancing of competing principles can't truly be rationally justified. This argument was made recently very well by Francisco Urbina in his book, A Critique of Proportionality and Balancing. My take is that Urbina succeeds on his own terms of showing that balancing decisions are not rationally justifiable only because he has adopted an unreasonably restrictive idea of what it means for a decision to be rationally justifiable. So I'm going to talk a bit about Urbina now. Specifically, he argues that a decision is rationally justifiable if and only if it's supported by a conclusive reason. A conclusive reason is one that wins out not because it's weightier than competing reasons, but because there's no reason it has to compete against on level terrain. In other words, whatever reasons may speak in favor of the other outcome are lessically inferior to the reason that prevails. That's what, to Urbina, is a conclusive reason. I read the book carefully and enjoyed wrestling with the well-crafted arguments and wrote a review in which I argue that that concept of rationality that is that strict excludes as irrational virtually all real-world decisions of any importance that people and institutions have to make. If instead we define rationality down to make the concept more useful for human affairs, then I argue proportionality absolutely can ground decisions rationally. And as noted, one of the claims made on behalf of proportionality is exactly that. Proportionality decisions are widely accepted as reasoned and legitimate. But I think a question that's worth asking, if we kind of move from the theoretical frame more towards the political frame, is under what conditions are proportionality decisions read as, perceived as, received as rational and legitimate, in particular by those on the losing side of those decisions? I don't have an answer to that question, but I think it could be important to the long-term fate of proportionality and proportionality courts. Looking ahead, which is always a hazardous affair, but I think there are reasons to think in years to come, courts in many places are likely to face challenges that now only courts in some places face. There are rising tides, as we all know, of political polarization, populism, and popular authoritarianism in many parts of the world. These trends make the political environments in which courts operate less hospitable. When courts get in the way of political agendas, I think we may see more and more vigorous efforts in more parts of the globe in the future to paint courts as unprincipled partisan or as distant elites that are contemptuous of the real people. We may be hearing more of the argument when courts buck political branches that their values are not your values. I think this raises some questions. Is a court whose methodology depends so openly on giving weight to values especially vulnerable to attacks of that sort? Does an attack of that sort gain potency as polarization increases? An answer might be no. What really matters to courts' popular perception is the outcomes that they reach, less so the legal reasoning by which they come to those conclusions. So courts may find themselves unpopular, but it's not because of proportionality, because few people actually will read what the courts say to ground the decisions that they make. That could be the case, but that response is at least in some tension with the idea discussed above that proportionality's methodology is in substantial part to credit for the effectiveness of rights protection in proportionality courts. In the time I have left, I wanted to do two things briefly. And one is to sketch out in the sketchiest possible way a research project I hope someone might undertake, and then to offer just a few thoughts on how courts, proportionality courts, can weather the challenges that may come. And I emphasize how tentative those thoughts are. First, to the research project. I'm curious about how someone might try to test whether the acceptance of judicial decisions based on a balancing of values is especially sensitive to whether one perceives that the court shares one's value orientation. I think it could be useful to understand more at the cognitive and psychological level how different kinds of reasons are received, perceived, processed. I don't work in the field of experimental political psychology, but I wonder whether someone who does could construct a study to get at these questions in a laboratory setting. Let me, in broad brushstrokes, sketch out what such a study could look like. There could be research subjects, right, who answer questions about their beliefs and what identifiers are important to them. And then the subjects are exposed to made up judicial decisions in rights cases. For all the subjects, the rights claim is the same and the outcome is the same. But some see reasoning justifying the outcome based on proportionality, and others see a more traditional precedent-based style of reasoning undergirding the outcome. Subjects are told something about the, again, made up judges who rendered the decision, such as their partisan affiliation and other identifiers. And this information is experimentally manipulated among different groups of subjects. And subjects are asked about their attitudes towards the ruling. Do they think the conclusion is well justified? Do they perceive the courts as fair? The research question is, in the group exposed to the balancing reasoning, do subjects' attitudes about the ruling and the court hinge on their partisan or identitarian alignment with the court more or less than the group exposed to the traditional legal reasoning? It would take a lot of work to design a study along those lines that could reveal meaningful results. And I'm not 100% sure it's even possible. But I offer this really as a hope that of the many people out there listening, perhaps someone has a better idea for how to get at these kind of basic features underlying responses to different kinds of legal reasoning. Okay, and to my last point, recent decades have been good for proportionality. It could well be that proportionality will face some new trials and challenges in the years ahead. I want to conclude with just two minor thoughts about what proportionality courts can do in the face of sharpening political conflicts in systems where they operate. And these are linked to things that we have learned from existing proportionality scholarship. So one way, the theory tells us, proportionality generates buy-in and contributes to the legitimacy of courts is its sensitivity to the concrete factual circumstances of cases before it. This means that when the facts change, the outcomes can change. I suggest that for that legitimacy mechanism to function, there does need to be alteration over time in which interests prevail. An alteration over time in which interests prevail, I suggest, might be able to strengthen courts' immunity to the accusation that judges don't share our values. Second thought, going back to Neil Peterson's finding that when the German Federal Constitutional Court invalidates statutes, in other words, when the counter-majoritarian critique of courts is at its peak, again, Peterson finds that in that circumstance, courts don't rely on the pure Alexi weighted balancing formula. Rather, they give more tailored, more specific reasons to undergird their conclusions. I think that may be because those circumstances are ones in which a naked balancing of principles does leave courts especially exposed to a the value-based critique I described before. Of course, I say again, it's an open question as to whether the specific rationale that a court gives for its conclusion is particularly important to how that decision is received. But to the extent it does matter, I suggest a greater specificity of the reason given for the outcome can help blunt the perception that one set of interests simply resonates more with the individuals on the bench than another set of interests. So looking back, work in recent years has vastly increased the sophistication of our understanding of the theory, law, and politics of proportionality. I'm curious to see what we learn in the years to come. Those are just a few thoughts on where we've come and what we might see in years ahead. Thanks.
Thank you very much, Jude, for sharing your thoughts with us. So far, we have had more theoretical, doctrinal discussions and judicial adjudication, but we haven't heard anything about these empirical studies that you shared with us today. And along those lines, I would like to give the floor to Juan Pablo Uribe, that, as I said earlier, will talk about the proportionality principle and restriction. Yes, Juan Pablo, go ahead. Thank you very much. First off, good morning to all. If you're in a different time zone, good morning, good evening. It is my great pleasure to be here with you. I would like to especially thank this invitation. As I said, I feel especially honored to be able to have this opportunity to share about these topics that I love so much. I would like to especially thank Diana, because Diana has been very kind to me. You know, the communication between she and I has been very kind. I would like to start by telling you the order of my presentation. I will be dividing my presentation into two. First, I will make some observations and preliminary notes in order to introduce you to the topic that I want to discuss today. And secondly, I want to discuss the scope and the methodology. And secondly, I will be getting into the details, and I'm going to think about the question that is so ambitious, so I'm exaggeratedly ambitious, that is in the title of my presentation. When, if there are any occasions in which social rights can be exerted without going against the Constitution. We will start with these preliminary ideas so that you can introduce you to this. And then we will be making some precisions. When, in what occasions, if any, we can restrict social power without affecting the Constitution? What Constitution are you talking about? Well, by my accent, you know, I'm Colombian. Are you talking about the Colombian Constitution, Mexican Constitution? What Constitution are you talking about? Well, let me just clarify. I made my PhD on the limits of freedom of expression in Spain. So I had, but Spain was paying my PhD, so I needed to address what was happening in Spain. I was in a period that where freedom of expression was heavily discussed in Spain. I'm Colombian, however, you know that Colombia is going through a post-conflict era after the peace agreement. So my idea is, as an investigator from Colombia, how to make, in order to reach long-lasting peace in Colombia, how to reach peace. I have no questions about that. Well, by installing democracy, democratic societies, the way they change conflicts. That's the only way. When there's democracy, peace can be achieved peacefully. So since the question was how to make peace in Colombia by setting up a democratic society, so my question and the question of all social investigators in Colombia is how to implement democracy in Colombia. So in my case, I was always away from my country because I was in Spain, and I was always interested in Colombia. So if I was able to make this summary to speak about the Colombian and Spanish constitution, these two constitutions are very different because Spain has a king. Spain and Colombia have different constitutions, different procedures. So it was good to compare these two constitutions. People from different nationalities, we all are in different democracies. We all live in contexts that makes us make several generalizations. But let us think in any of our constitutions, when could we restrict social protests? And then we can talk about this, the details depending on the country where we are. But allow me to generalize so that we can make this open question. It doesn't matter if this is a Mexican or Spanish constitution. Let us speak broadly so that we can develop a general theory, constitutional theory on when is it possible to restrict social protests. Second point, I want to warn you, and after the excellent previous speaker, you will realize, but I want to just disclose this, that I am a criminal, I work in the criminal area, not in the constitutional area. So I will be particularly focusing on penal or criminal restrictions to social protests. You cannot regulate social protests or riots with administrative procedures. You know, we cannot do this administratively. I don't work with administrative issues. I work on criminal issues. If I speak about administrative issues, I could make mistakes. When I speak about restriction, please remember that I'm speaking about criminal restriction of social protests. When social protests reach a limit in which we say this is a domain of the criminal law, when by protesting, I can be charged because of a crime. So let us focus on that question. And let us now see when, if there are any occasions in which we can criminally restrict social protests or riots without going against the mandates of the Constitution. But just to clarify, in my title, for most of you, is not very subtle, but this includes two prongs. First, that I am starting from the fact of a presumption against any criminal regulation of social protests. I think that there should be a presumption of constitutionality against any regulation, criminal regulation against social protests. Such presumption is based on the importance of such social protest, because social protests or social demonstrations is a way to exercise the right of association, the right to freedom of expression. This is just to simplify. And these are the tools that citizens have in order to try to control the power of those that rule or run the country. This is a way to control, to supervise. This is a way to control the rulers, and citizens become the controllers of rulers through demonstrations. So I start with this presumption. I will speak very briefly about this. My lecture is very ambitious. If you want to find out why is it important to run the risks, coming from a social demonstration, we can talk about that. We can speak about political philosophy because I love that topic. And we can also speak briefly about the importance and why risks are run when we have social demonstrations. It has to do not with individual rights, but social collective rights. The right to the right of freedom of expression, the right to associate themselves, has to do with autonomy. This is a political justification because we need the right of demonstrations to maintain a democratic framework. Freedom of expression is a necessary element to position and to maintain and to establish a democratic society. So this is my presumption against authorities that wish to criminally restrict social demonstrations. We can later talk about what's behind such presumption. Number two, there's another starting point. This is regulations, even criminal regulations of social demonstrations. This is a matter of constitutional right. It is not an issue of criminal law. I think that regulations of demonstrations is a constitutional right issue. When I made my PhD, I realized that criminal lawyers say when a crime stops to be a crime because the person is following some justification of the exercise of its constitutional right. So here we need to see when we can criminally deregulate a social demonstration or the exercise of freedom of association or freedom of expression without going against the constitutional mandates. So this is where I go deep into this field that you know better than me, which is the constitutional field. Number four, for the fourth position, following authors such as Richard Fallon, I understand that the task of courts is not just to interpret the Constitution, but rather it goes one step further because not only does it deal with the interpretation, but it tries to enforce, to implement such Constitution. This is why he speaks about interpretation of Constitution, but rather enforcement of the Constitution. First to interpret the Constitution and then to implement the Constitution to make sure that the Constitution be the one that will be ruling the social life of a specific society. That there will be a social scenario based on such Constitution. And also by following the same author, I believe that this cannot be done by just a group of Chief Justices. A group of Chief Justices cannot enforce Constitution. For example, freedom of expression. Freedom of expression is in 198 constitutions of different countries. It includes China and many countries where there's little freedom of expression, but actually it is little implemented in some countries and in very few historic times. Freedom of expression taken to practice, taken to social life, where people speak freely without fear to consequences. Those cases are very few. So it is evident to me that courts need to try to implement the Constitution. It is evident, as I said, that just a group of Chief Justices cannot do that. That's clear. There are no Chief Justices on the High Court that will make to implement the Constitution in the different country for the different social interactions, because we have millions of social interactions. So how can a Constitution be implemented? We need to have the commitment of all the social stakeholders. This is with the rulers and the people, the civil society. There needs to be a joint commitment from the executive branch, judicial, legislative branch, and citizens, right? So what has to be done? What do the Chief Justices need to do? They need to oversight, they need to supervise, they need to encourage, and to review the commitment that we have in order to implement and to enforce such Constitution, right? It seems to me that this is a role of a High Court, and I will be talking about that, how to take the Constitution to practice. So what I'm going to share with you today is the guide so to speak, or the strategy to try to encourage, supervise, oversight, control, and to review the efforts that the social stakeholders make in order to regulate and in order to enforce the Constitution having to do with social demonstrations or social protests. This is something that the Supreme Court of the US carried out. I don't want to be pro-USA. In Spain, people would say that I was a member of imperialism, but no. If you tell me in Angola, there are better solutions, or in Ethiopia, there are better solutions, or in Chile, there are better solutions, or if in any other country there are solutions, I would go there, I would resort there. It's not that I just want to talk about the US solutions, but I want to show you how these commitments are guided with this commitment to the social demonstrations. This is the American way. And also in this same observation, I can tell you that I will be making a free interpretation of the jurisprudence of the First Amendment of the US Constitution, basing myself on something that I like, which is the Brennan judge, Judge Brennan. Judge Brennan, he was very famous in New York Times versus Sully. So after these precisions, we can now get into the gist and to ask ourselves when, in what occasions, if any, is it constitutional to criminally regulate social demonstrations? When is it possible? When can you criminally regulate social protests without going against the mandates of the Constitution? That's the first question. What the US doctrine does to deal with these topics is to divide these complex questions into several questions, expecting not to have a big level of abstraction so that we can reduce the complexity of these questions. So the first question that comes out from this division is, such criminal restriction whose constitutionality is being reviewed has as a purpose to reduce social demonstrations because of the content, the message of such demonstrations, or irrespective of what the demonstrations are for. It will just criminalize the demonstrations irrespective of the content of the demonstration. So here we are looking at a restriction based on the content. But for example, we could also limit this demonstration if there's xenophobia, or because they burn up churches, or if they criticize the rulers or praise criminal groups. So the regulator heard what the demonstration was about, and they will be regulating it criminally. So this is the content-based restrictions. You can see that the regulation of the social protests, perhaps they're in front of a hospital and you cannot make noise in front of a hospital. I don't care if they're making noise because they're fighting against or in favor of women, or in favor of a certain race, or in favor of a political party. I don't care what they're making demonstrations for. They're just making noise. You cannot be next to the hospital without noise. Or now that the environment is in danger, you cannot develop 45,000 flyers because flyers are bad for the environment. You cannot be using all that much paper. So these type of regulations will be neutral to the content of the demonstration, right? In the doctrinal, the freedom of expression in the US, if you have a content-based regulation depending on the classification made of such criminal restriction. In that case, you are putting yourself at risk. If you make a content-based restriction, then practically you don't have the possibility of a claim that this is constitutional. You cannot claim that the demonstration is constitutional if this is content-based, because there will be a strict scrutiny. In practice, it's difficult, but in theory it's difficult to do, but in practice it's terrible. there are one or two exceptions, but generally speaking, content restrictions cannot be made of social demonstrations based on content. If this is a neutral restriction, then you have better possibilities, right? You have better possibilities of it being constitutional because you will not be under scrutiny. You will be having just half a scrutiny, so to speak. Later, if you have questions, we can analyze all of these factors. But I'm going to tell you that I'm going to focus on regulations of social demonstrations based on content. And since I'm going to be focusing on content-based regulations, I want to make a comment about a content-neutral regulation that I can think of. And this is something I wanted to reflect upon with you. And this neutral content regulation is that, well, you could say that regulation of violent demonstrations could be a neutral content regulation. You can express any message. You can say that you don't like women, you don't like gays, you don't like people from certain race, you don't like people with these of the left wing or the right wing. You can say that, but you shouldn't use violence. You cannot say that harming others. Let us not pass this message by using Molotov bombs. And I want to say something. Mr. Garcia Mao says that balancing and weighings bring something that we don't like. But the opposite happens to me because I say, what is the level of protection that the Constitution provides to social demonstrations when demonstrations are violent? I don't know, because I'm very conservative now, but I've seen that that doesn't happen. When there's a violent demonstration, there's no constitutional protection. And here there's something that I would like to discuss. Maybe we can discuss it here. Maybe you can help me think about an exception when violent demonstrations will have constitutional protection. When is there an exception? When demonstrators are defending against the authorities. Please think about this, because from the criminal viewpoint, it's very easy. If I'm a demonstrator and if I am exercising my right to association, to expression, and a police comes and beat me because he wants to restrict me by using force, criminally, there's this assault, there's this aggression to me. Here we need to include proportionality. Here we will win because of the legitimate defense. But I don't like to get into the criminal area to defend the one that is defending his or her constitutional right, defending that right from the authority that is curtailing the right. Here we're facing something very complex. Is force allowed against tyranny, against those that remove human rights? This is another type of question. So from the constitutional viewpoint, can I defend myself from that policeman? So let us see that when you are protesting or demonstrating, people are the ones that are demonstrating, and people are the sovereign figure. And so the authorities will say, I will not pay attention to this structure, and I'm gonna skip it. So one, how will then come and restrict or limit me? Why? The employee will tell me not to do it if I'm the employer. This is a question that I have. I don't know if you can say anything about that. But anyway, my point is that I believe that social demonstrations, when they are violent, they have little or no constitutional protection, right? Okay, after this clarification, I'm not gonna dwell into the neutral regulations because those are administrative regulations. I would like rather to talk about non-neutral content regulations But when will we rule on a social demonstration because of the content? Usually when the authority believes that it is necessary to limit social demonstration criminally because of the message sent, is because they believe that the message can cause 3 types of harm. This is a typology by Cohen. There could be 3 types of harm based on such regulations. First, he doesn't speak about, well, there could be criminal regulation of the message because the message causes direct harm. The message automatically and immediately, the message can produce some harm. These are the racist messages or messages of xenophobia or discrimination or insults, etc. And the second, he speaks about environmental damage. What is environmental damage? Here we're talking about messages that if allowed, if these messages are not regulated criminally, those messages could create an environment of hatred, hostility, right? Or poor treatment, discrimination to minorities, right? In the future, if this becomes normal, messages like women cannot make decisions or women are meant to stay at the kitchen, in the long run, that will create some symbolic violence because this violence will go normal, right? This is the environmental damage. We're thinking about the future. If we allow messages against women, against people from certain race or trend or gender, if that is allowed, there will be an environment in which there will be discrimination. And the third one, there's another one which would be an indirect harm, right? Indirect harm is when the message cannot produce a harm itself, but can persuade the audience getting the message for the audience to perform such violent acts or illegal acts or criminal acts. Example, let us destroy the subway. Let us kill this homosexual that is waving the gay flag. Let us step on the black people. You know, these are messages that persuade people to act. And so in the US doctrine, in my opinion, and rightly so, rarely these types of damages, direct damage or environmental damage, can justify the criminal regulation, of social demonstrations or the message. That's a bad reason, right? So these type of restrictions that try to control environmental damages or direct harm go through scrutiny tests and they usually lose. I just saw 2 exceptions in which that is accepted, but this test is really lethal. I believe that this is right. And let me just get away from the legal aspect to speak about philosophy. What I care about when I study these topics is how to achieve peace in Colombia. The easiest way, well, it's not easy, but the fastest way is through democracy, by having democracy, because democracy accepts conflicts, right? Democracy accepts conflicts. Democracy knows that it cannot do away with conflicts, but it transforms conflicts. It places them on a place to settle them peacefully. Just give you a Colombian example. Until recently, there was a conflict in Colombia with the FARC, between the FARC and the state. That was not a democracy because there was no transformation of conflict into nonviolence, into nonviolent ways to address this conflict. In a democracy, political, ethnical minorities try to increase their political capital by using the tools from democracy, the right of association, the right to expression, social protests or demonstrations, they try to get the buy-in from the public opinion in order to settle those differences. So in democracy, efforts are made in order to transform conflicts from violent to peaceful, like FARC with weapons. I'm telling you this because I was there. For example, we had many people in the FARC, not all, because there's still conflicts in FARC, but I've marched together with FARCs. I've been in the demonstrations with FARCs. I've seen FARCs with my own eyes. FARC should express their ideas, and they try to gain political buy-in by marching or by demonstrations. There were some others demonstrating for many topics, but FARCs were demonstrating. This is beautiful about democracy, such transformation, because they no longer use weapons, but they rather demonstrate it. When you say, no, they cannot march, or the left-wing people cannot demonstrate, or homophobic people cannot demonstrate, when you start restricting social demonstrations, because there could be an environmental harm, direct harm, what are you telling them? If you want to demonstrate, go get your weapons, but that should not be the message. They're making efforts to address this conflict through non-violent means, you know, as minorities are trying to demonstrate, but they're not using weapons. So you need to allow for demonstrations. I would not approve. In my PhD thesis, I saw a demonstration in Granada in Spain where they burned the image of the king. That was restricted in Spain because burning the image of the king was a crime. I don't think that should be a crime. I don't think that should be restricted. I don't think that's physical violence. This was just demonstration and a theatrical demonstration of burning a portrait. Yes, the demonstration was destructive, but you know, they got away from violence. In Spain, also they criminalized the tweeters against the crown or against the power. I don't think that should be allowed because they're using the expression and art to depict the conflict. They're not resorting to weapons. But as I was saying, there was a third type of harm, indirect harm. Indirect harm in the short term here. What regulations are doing is to try to control the effects of a message that could reach the audience, and the audience may be persuaded in order to engage into an illegitimate action or a crime. How can we regulate it? When is that possibility constitutional? I believe, I'm not saying that going and kill the King of Spain is right. No. If you look at the portrait of the king, one thing is to burn the portrait of a king and something else is to go kill the king. Criminal regulation needs to focus on the audience that sent that message. But what has to be regulated is a member of the audience that says, oh, they made me do it. If we start regulating from the message and not who sent the message, that would be very difficult. You see the killings in the US and they say, oh, I killed because I watched the film, or because Metallica made me do it, or because that music made me do it. You know, all of that has this potential. This is something you cannot control. So it's better to control the receivers. You need to see who's burning the king's portrait or sending those messages. So as I was saying, in the United States, the high level of scrutiny goes down when we're talking about an expression that meets two characteristics. The first one, a message that is directly addressed to encourage immediate use of force or immediate violation of the law. Immediate use of force is that some years after Brandenburg, this was applied in another case. Someone who said, we will come later to take the streets. That's not immediate. They would say later, later. No, it has to be immediate. Why? Because if it's not immediate, then it is not necessary to limit the message, because then the authorities can take measures to prevent that. So the authorities will say, okay, there will be threatening, we will control the threat to avoid it, because that was not immediate. And secondly, that is feasible to be, that some actions be produced, right? It needs to be feasible for whatever is said or that threat to be credible. Otherwise, it could not be regulated constitutionally. So in general terms, this is what I wanted to share with you. And now that I'm thinking, I am summarizing 5 years of my research. I'm truly convinced that I was just very superficial. I would like to dwell more on any of the topics that you are interested in. You know, I give a very, very brief or superficial presentation. If you have any questions, any specific questions, please let me know. Thank you very much for your attention. Thank you very much, Juan Pablo. This is a topic that has been around from early on, but the topic is just in the air. But we are not really implementing tests of proportionality in areas such as the criminal area. It is clear that there's this principle of proportionality in criminal law. But what about the test and how a test aligned with the criminal regulations? Hopefully we can discuss this a little bit later. There are specific questions for each one of you. There's a general question, but there are other questions about your lectures. So I suggest the following. I will make the general question first. After that, I will ask specific questions to each one of you. I will ask 3 questions to each one of you, and then you'll give us the answers. Let us see how many rounds we can take. If anyone wants to take the question made to the other speaker, go ahead. You can take questions. There's a general question about the use of the strict, medium, light scrutiny test. What do you think is the relationship between one test or the other? If there are 2 different ways of making constitutional adjudication, scrutiny test, if it is strict, medium, low, because there are constitutional restrictions in Latin America that have tried to enforce a test that will merge the 2 proposals. This is the proportionality test and levels of scrutiny. So in general terms, please tell us, with respect to your own presentations, that's a general question. There are some specific questions for Jude. One question, Jude, is about your reading about the Urbina's text, because according to this person, to the person that asks in Facebook, Urbina, not only does he attack rationality of the test results of the application of the test, but also utilitarianism. A lot of utilitarianism. It would seem that applying the proportionality test is to apply a moral and legal doctrine that is based on utilitarianism, and how to then understand the rights. And he also suggests another problem regarding utilitarianism, and this is comparability and commensurability. It would seem that what the test does is to allow to rationalize comparisons that are not admissible or admissible. This is comparing apples and pears. So since you know the Urbina's text so much, this person would like to hear your thoughts. What is your position about utilitarianism and also incomparability on the test? And the second question is if you could elaborate on the quantitative work on proportionality, the quantitative work on proportionality. There's a lot of doctrine work. There's an endless discussion about the philosophical, ethical, moral grounds, but quantitative work of proportionality. That's not very well known. Can you please tell us about that work? If this is quantitative work that focuses on some jurisdictions, such as the German, the Canadian, or if there's work on other type of jurisdictions, for example, using the test of proportionality, such as what happens in South Africa or in Latin America. Are there quantitative results about that? And finally, one question. What is the use that constitutional courts or constitutional judges have given to the proportionality test in the United States? Have they used a proportionality test in the United States? Or is it rejected because of political reasons? Are they using the proportionality test in more formal ways? Are they using proportionality or not? So these are the three questions that they have for you. And for Juan Pablo, the first question is, how adequate is the proportionality test for the criminal domain? This is a $1 million question. Because of the restrictive nature of the criminal interpretation, don't you think that the proportionality test is extremely generous as to what the state or legislators can do? And if you believe that it's better to have to examine the scrutiny levels that gives a more strict leeway. And second, to elaborate on the proportionality analysis. Could you please tell us what do you mean by protest or demonstration, and what do you mean by social? What is a demonstration and what is social? Can you define social and demonstration? Is it social because of the topic? Is it social because of the amount of people involved? Or is it social because of the critical nature of the public institutions of the state, or because of institutions that are not state institutions that are important, such as church? They could perhaps understand what you mean by social demonstrations, who against whom, etc. And also other people want to know if you can speak about social demonstrations. Thinking about social demonstrations in that terms, abstract terms, or if we need to think about social protests in constitutional provisions and political traditions, historic, cultural traditions, in order to give shape to this idea. If the variation among countries is not too huge so as to speak about such a broad category. And this has to do with what they asked you before. There are many questions asking you to elaborate. What do you mean by the peoples? Because you're saying the peoples here, peoples there. What do you understand by peoples? Social members in these social protests or demonstrations. When you speak about the peoples, is that groups that ideologically are against the government, or groups that are under certain socioeconomic conditions? If this is a right wing, because you spoke about people that seem to be more on the left wing, but if the right wings peoples is also the peoples, what do you mean by that? And what is their social protests about? And so with these broad questions, I will give you the microphone so that you can please take those questions. Can you please start, Jude?
Sure, I'm happy to begin. Thanks for those wonderful questions. I'm going to say something about the general question in connection with my response to the third question to me about in the United States, what happens? And the first question about strict, medium, and light scrutiny. Briefly, in my view, the United States has flirted with proportionality several times in its history, but never openly kind of confessed itself a proportionality jurisdiction. If you want to hear more about this, Alex Sweet and I wrote a piece in 2011 in the Emory Law Journal, kind of going through this, going back to the 19th century. In dormant commerce clause jurisprudence, we see something very like the proportionality test cropping up in our Supreme Court's jurisprudence. And then again, early in the years of the rights revolution of the Warring Court, what hardened into the tiered scrutiny framework for us started out, we argue, as a more flexible balancing approach that took seriously the issues on both sides. But the narrative that we tell based on our reading of the history is that this did kind of ossify into a very rigid set of tiers, which are effectively kind of a very light scrutiny. We call it rational basis, strict scrutiny, and this intermediate scrutiny. Even so, if you look at how these tests are articulated even today in the US doctrine, they map by their language fairly closely onto different parts of the proportionality framework. So the question we ask in rational basis review is very similar to the suitability question asked in proportionality, but in a rational basis case, that's where the analysis stops. What we don't have in the US is this concatenation, this linking together of the different tests. Our formulation of the strict scrutiny test actually sounds a lot like a least restrictive means test, but famously, it has been applied in practice, exactly as Juan said, to be fatal in fact, strict in theory, but fatal in fact. At least that's the kind of historical received understanding of how that's been used in practice, so that the mere application or the invocation of that test, it's a foregone conclusion how it ends. Empirically, that doesn't, it's a little more complicated than that, but that's the rough idea. I appreciate also the great questions about the Urbina book. Yeah, I don't think that a rejection of Urbina's view or a commitment to proportionality in any way commits one to utilitarianism, in part for this may be a simplistic answer, but this is nowhere in the proportionality test are we exclusively concerned with utility. There are values, interests, principles at stake that reach beyond what I think a utilitarian cares about. With respect to this long-running debate about incommensurability, again, I think the question comes down to what we think the concept of rationality really means, and how demanding a concept of rationality we want to hew to in the context of legal decision-making. My view is we should have a concept of rationality that's actually useful for the kinds of complex decisions humans make in human affairs. And that the much stricter version of rationality that Urbina, the concept of rationality that Urbina takes as his own, I think it's disfavored by me because I think it's so distant from the real decision-making context people have to make. People make, I would say, reasoned, rational choices between things that are formally incommensurable all the time. To briefly, I'll try to keep this brief, but to use an example from Urbina's book, he takes kind of a different view. He says, if you care about different things and there's no common currency to exchange between them, you can't say a decision made on those basis of those things, taken together, is a rational decision because you don't have a way to trade off between the two. He gives the example. if you are buying a house and you care about two things, you care about its beauty and you care about its size. You can't make a rational choice about which house to buy based on beauty and size because they are not commensurable. I don't think that's a very useful concept of rationality. Certainly, it seems to me, we can say if we had, two houses, one's just a little bit uglier than the other. Let's say the paint is a slightly less attractive shade than the other. But the slightly uglier house is twice as big. I think we could say the choice for the bigger, uglier house is a rational choice. For me, that counts. We could give reasons to justify that decision, and that would be different, I think, than flipping a coin. Right. So to Urbina, the choice between those two houses, I think, it could only be, or could equally well be made by flipping a coin. There's no difference between that and trying to give a justification. Just a one-time final quick point on this. Even if we think about properties that decompose into smaller properties, then we really is there really any decision that doesn't involve incommensurables? Take beauty. If beauty is a function of proportion and also color and maybe other factors, how do we weigh those together to decide what is the most beautiful thing of different ones on offer? Or location. So my point is, I find a concept of rationality that maps onto human decision making and the kind of decisions that people make more useful for me. And I think we make reasoned decisions all the time based on incommensurables. And I think it's appropriate to have a concept of rationality that recognizes that. Last question about quantitative work on proportionality. Again, the real pioneer here is Niels Petersen. There may be some newer work that I'm not familiar with that does what Niels does, but I want to say a little bit about what his work does, because it really is, I think, sort of gold standard. My recollection is, for his study, he looked at all the cases for 3 courts that involve proportionality. And the courts were Canada's Supreme Court, Germany's Federal Constitutional Court, and South Africa's Constitutional Court. And read them all and coded them, what the issues were, which party won, what step the decision was decided at, and kind of how. So it really is a fantastic resource. And this, again, because it goes over time, these courts have been doing this for varying lengths of time, but you can also see change over time in what courts do. So I think it's a fantastic resource. It's a book. It came out first in German, and then it was translated, and I think a somewhat abridged version in English. But I recommend that very highly to everyone, and I encourage people to do work in that vein. I think that's extremely important work. It takes so much work, right, to get that comprehensive view, but I think it certainly pays off for other scholars. Okay, that's it for me.
Perfecto. Muchísimas gracias. Y,
thank you very much. Juan Pablo. I don't want to miss this opportunity. I would like to congratulate my colleague for this brilliant presentation. She made such a brilliant presentation that I thought I wouldn't be able to step up to the plate. Her presentation was brilliant, was really encouraging. Congratulations. Diana, if you allow me, I will change the order of the questions. First, I'm going to discuss this political issue that I really love. Maybe I was not very accurate, and now I can draw some conclusions. So I'm going to start there. What happens when we speak about democracy is that sometimes we're speaking about a good government, good governance. What a democratic government is what a good government is a democratic government. But that definition is not good for the analysis. Let us start with the meaning of democracy, and then what the people's is and demonstrations. Democracy is a society in which rulers must listen to the release before making decisions about the common fate. So this is defining democracy as opposed to dictatorships. In dictatorships, rulers do not listen to their people before making decisions. The people are just like secondary actors, whereas in democracies, people that are ruled play a more active role. It's like a house. Parents need to listen to their children before sending them off to the university or before asking them to eat. So these societies are more democratic instead of those in which the ruler makes decisions without listening. So what does democracies do? They create a scenario in which the people live. Let's go back to the before the French Revolution. The king was top. So what democracies do is to bring the level of the king here through the principle of legality, division of powers, frequent elections. They have some mechanisms to bring the level down. And so what we do, let us go back to the pre-modern era, and the people here become citizens. How? With some tools that give them freedom of expression. So the person that is here, if you give them the right to associate, to demonstrate, if you give them the right to demonstrate, they will never be crushed by these. So by bringing him down and the people up, you will be allowing them so that they can interfere on the decisions, so that they can have voice and vote. This is what I understand as a democratic society. The one that makes that people governed will have decisions, and the governed people is the people's. Yeah, the people's is the one that is not in power, be them left wing or right wing, or doesn't matter. By definition, people's, and here I'm using Machiavelli, is a negative instance. Who's the people's? The people's are not rulers. Those that are not in power, the political minority, that's the people's, right? So this is the actor that is not in the government. This is what I understand as people's. So the people's have an influence or becomes part of the social scenario where decisions are made through two voices, a positive voice and a negative voice. What is a positive voice? Diana is the ruler, and I tell her, you know, I have a better proposal of tax reform, for example. Look at my reform. This is how citizens participate. They propose, they give ideas, right? They take what's public to participate. This would approach us more to a citizen of Aristotle, for example. And also, it participates with a negative voice. It brings us more to the idea of democracy in the US. The citizens never propose, because this is what congressmen are paid for. Citizens want to watch American football, baseball. Citizens want to live their own life, but they're willing to react. They're willing to react with criticism, or by controlling, or by supervising the power of internal power. This is the rulers or a foreign government, if they ever come meddle into their affairs. So this negative voice that the peoples use to control, to supervise, to contradict, this is what I call social demonstration or social protest. This is what I call social protest. Peoples is the ones that are not in the government, and social protest or social demonstration is the activity through which their negative voice of the peoples is present to make decisions, right? So in Colombia recently, the government proposed a horrible tax reform, a terrible tax reform. What did peoples did? Peoples through social demonstration had an influence and debunked this tax reform. This is social demonstration, social protest, what people do when they say representativeness or me speaking about my representative, that is useless. I'm going to take this in my own hands, and through public means and public space, I'm going to control my rulers. This is what I understand as social protest or social demonstration. Doesn't matter if this is left-wing, right-wing, machista, it doesn't matter. People's is a negative entity. People's are not in the government, and social demonstration is the negative voice to have an influence on public matters. So this is regarding these questions, political questions. Variation of social demonstrations in between and among countries. Yes, there are different types of demonstrations, but this is not all that significant. In political philosophy, I like Machiavelli. Machiavelli is from the Renaissance. He didn't even live modernity, and Machiavelli showed how protests or demonstrations took place in Rome. And this is how demonstrations take place in Colombia. Having a ruler or the governed people that do not want to be crushed by the ruler. These are universal scenarios. And this is something that we will continue to face in the next 2 centuries. So I would believe that there are not all that many differences among the different demonstrations among countries. I think that social demonstration, in general, generally speaking, is the same in all countries. According to the social space where we live today, there are not all that many differences. And finally, the different levels of scrutiny. I believe, Diana, that it's important to have different levels of scrutiny, and what going for one level of scrutiny or other, this leads to 2 factors. First, mistrust or distrust. When the Supreme Court of the US distrusts other actors, they place scrutiny because they believe they're not doing things right. So there's distrust and they exercise scrutiny. I don't know if you're doing things right. So I take this to social demonstration. Recently, the mayoress of Bogota said, this social protest or demonstration, what has been the cost of it? Jude and everyone in Colombia, something interesting happened because Colombia is, the people in Colombia never speak up. Historically, people never speak up, and suddenly, 4 or 5 months ago, we went out demonstrating in the streets right in the middle of the pandemic. So that was very unique. And the mayoress said, yes, you came out to demonstrate under the pandemic. We're trying to control the pandemic, and you came walking out in the middle of the pandemic because of your demonstrations. The first cost. Second is there's a lot of crime rates in the country. There are thefts and killings. Why? Because of social demonstration. This is what the mayor said. So she said that the demonstrations had a high toll for the society. And what are we getting in return? She asked. For the youth to burn up things. Yes, there were some posters of Che Guevara hanging. So for them to burn up that area, well, we are paying this high toll. Diana, can you see that a representative from the executive branch can have a misconception of social demonstrations and benefits? Social demonstration is important for the youth to mature. No, social demonstration is the right to association, to freedom of expression, and in order to control rulers, in order to have democracy. So the member of the executive branch regulated the social demonstrations because she didn't understand what the benefits were. So these type of issues is what prompts the Constitutional Court or a Supreme Court to say, I need to check this up because people are cannot see the benefits of these demonstrations. First, this is the level of distrust, and then the level of concern for a particular topic. Let us think for a second that Professor Mathews does the scrutiny tests. He has limited resources. He knows that in the High Court, he cannot check each and every decision made by the legislative or executive branch. He cannot check each and every one of them. What does he have to do? As any person with limited resources, he needs to set priorities, right? So Professor Mathews says, I'm gonna use a low scrutiny test in porno messages, for example. Why? Because if we don't have porn, our society will be more boring, more conservative, less interesting. But we need to have a democratic society. So I'm gonna use a low strict test in order not to check up on porn messages. But in political messages, those need to be with high scrutiny. If they start misregulating political messages, we will become a tyranny. If we're a democracy, we start demonstrating against regulations of porn, for example. How are you gonna rule porn? Porn is the best we have. We can do, yes, but if we rule political discourse and we allow for misregulation, we will become a tyranny and we won't be able to demonstrate. We will be under tyranny. So this goes to show a higher level of concern. So different levels of scrutiny for porn messages and political messages. Why? Because of priorities in the decision-making process with limited resources. Distrust and level of concern. These are the two elements that lead to higher or lower scrutiny levels. And finally, proportionality test in criminal law. I believe that criminal law was born from disproportionality that I see in authors from different parts of the world. Like, for example, Blackstone said that it's better to have 10 guilty people than one innocent people to suffer. By Voltaire, it's better for 2 guilty people to escape than condemning or accusing one innocent person. It's better to have 20 criminals at large than one innocent in jail. Several authors have said that it's better to acquit 1,000 guilty people than killing one innocent person. So the criminal law is based on disproportionality. There are two errors, and we want to prevent one more than the other. How can we avoid that? By having criminal principles, innocence presumption, restrictive interpretations, and this is where criminal law comes from. So what happens, Diana? Oftentimes, proportionality tests, when they're very general, they are based on those presumptions and disproportions, but the more they mature, the better they become for the test of several factors to specifically focus on each factor for those that need to make the decisions, to make a quick decision and a good decision. So to me, as a criminal law expert, there are several factors that are similar to proportionality, but now they are much mature. This is the objective imputation test. In criminal law, I don't see test of multiple factors, but all of those are based on those principles, and they have been misdeveloped, but they're all based on the idea of disproportionality, not proportionality, but disproportionality. The proportionality test is always based on disproportionalities of two harms or two hazards. This is developed along the years, and the concept hasn't yet evolved too much. I'm reading an author called Schauer. Schauer explains that there are different levels of maturation. So the criminal law has much more maturation than the constitutional law is much more mature. So moving from criminal to those tests in constitutional is very natural. As Schauer said, this is a way to give flesh to the skeleton of the institution through several factors that will allow citizens or policemen or legislators or judges in each of those factors to observe what the factors that may lead them to make good decisions. So I think that the test of proportionality is an immature version of the tests that I see every day in criminal law. Very well, Juan Pablo. We are nearing the end of this seminar, and we're nearing the end of our Congress. Now that I have you here, I want to ask one more question. And the remaining questions, we shall have time to answer them later on. One question for Jude. You spoke, Jude, about legitimacy of the court decisions, when to use the proportionality test or not. The question is, can you please explain how do you measure legitimacy? Because what people care is the substance, the decision, rather than a methodology, one or the other. So how an investigator or researcher designs this type of questions to reach a conclusion? Doesn't it depend on who you ask for? Who you ask? If you're speaking about social legitimacy in broad terms, or are we talking about people affected by the decisions, or if we're talking about people that are part of the legal community? And also, they would like to know if there's something about the different ways of saying that judges in courts, not only different courts in different countries, but perhaps somehow there need to be political preferences or party preferences, ideas on what rights are and the limitations of rights and the methodology that judges use, the constitutional judges use to decide, like differences between and among courts. And for Juan Pablo, one question, well, several questions actually. I'm going to summarize in one. They ask if there is an example. Can you please tell us more about the Colombian Constitutional Court or about the Supreme Court of Justice in the criminal area that has explicitly used the proportionality test? Because you've said that there are some more sophisticated tests to study certain things of criminal law. But what about the proportionality test in these terms? Has this ever been used? Or there are more advanced tests that they no longer use the test of proportionality? Can you please tell us about that?
Thanks for those great final questions. With respect to the first one, I'm glad it was asked because I want to make clear there are, of course, different realms in which, among the different conversations I described going on about proportionality, more than one of them is interested in questions of legitimacy of different sorts. Questions of a theoretical or philosophical nature about proportionality ask about the legitimacy of courts undertaking these kinds of decisions with this method in a political theoretical vein. I want to be clear. I consider personally those questions way above my pay grade. I don't think of myself principally as a political theorist, and I don't offer an account of what makes a decision legitimate. What interests me particularly, however, is perceptions of legitimacy. Not mine, but more broadly. What are the circumstances under which legitimate decisions are broadly perceived as legitimate? There are advantages and disadvantages to approaching this question this way. And again, this question is interested to me in this kind of broader political analysis of proportionality, whether and why and under what circumstances proportionality takes hold in the system and enjoys, and to what extent and when courts doing proportionality enjoy broad support. It's nice to be able to outsource the question about legitimacy to the broader public and not have to offer a theory of legitimacy of my own. But it is empirically hard to get a handle on that question. Under what circumstance is the perception that different kinds of decisions are legitimate? Again, in the briefest possible, most tentative possible way, I sketched out an idea for a kind of study to ask that question with research subjects in a controlled way. I would be interested in what the results of a study like that would show. It may be, as the question implied, people don't care about the method a court uses to reach a result. People care about the result. That certainly could be the case. If that's the case, I think that calls into question at least some of the research, some of the theorizing about proportionality's acceptance, which hasn't been based on that kind of granular empirical work. With respect to the second question, I hope I understood the question correctly. I'm going to answer what I think the question was, which is about the appropriateness of a diversity of perspectives and approaches to proportionality across courts and across places. And I think that's absolutely the case. One of the things that has, I think, been one secret of proportionality's success is that it travels well precisely because it can be filled with different content in different places. If we, and I mean that on more than one level, which I'll describe, if we look around the world to courts that do proportionality or take the label of proportionality, we see that what they do is in many cases quite different from one court to the next. To give one familiar example, South Africa's constitutional court proudly embraces the level of proportionality, but they do the analysis in a kind of integrated way that doesn't march through each step as reliably sequenced as, say, Canada's Supreme Court does. And South Africa's courts not alone. Taiwan is another jurisdiction where proportionality is used, but also in a bit of a looser, more flexible way in terms of its structure than in the jurisdictions that at least English language scholars like myself are more familiar with. And also, outcomes differ. Even if the steps of the test are the same, proportionality leaves room for courts in different places to weight things differently. And I think that's entirely appropriate. There's no reason, I think, to expect ex ante that people all over the world would see these value conflicts, these principle conflicts the same way. So yeah, that's my my final responses to those two very good final questions.
Muchas gracias, Juan Pablo.
Thank you, Juan Pablo. Yeah, thank you, Juan Pablo. Well, this was a very interesting question. I need to recommend this so that you can see how this was seen in Colombia. P391. This is the ruling of P391 2007 ruling. You can look at it because this is a sentence of a ruling of 323 pages. It's a huge one and by far is the best. A bit is disordered, but this is the one that deals with this topic in further detail, and this allows us to see how the Constitutional Court tries to implement and enforce the right to freedom of expression. And most definitely, Diana, what you can see is that there is, yes, already a degree of sophistication. I cannot share my screen, but let me read a bit about the language used so that you can realize presumption in favor of freedom of expression, imposing some charges to the authorities that will attempt to limit freedom of expression. Just as in the criminal law, disproportion leading to presumption of innocence because we want to prevent making errors. This is not to indict innocent people. Presumption of coverage because of the constitutional right in view of other constitutional rights in case of conflicts. So here it says that there's no proportion among values, that there's disproportion. Freedom of expression should have more importance. So this ruling or sentence is very much more similar to what I was telling you. And also this is supported in the US doctrine, because the US doctrine is the one that has been thinking about this for longer. The US has been thinking longer about this more than other democracies. So these are more refined tests. So I would say that we don't use this with a constitution proportionality test, but rather we see a more complex structure, including scrutiny levels. This is a difference between what the Constitutional Court in Colombia proposes and what I propose. When I spoke about environmental damages, I was talking about this discourse. In the United States, they understand that regulating hatred discourse is unconstitutional. In Europe and in many countries in Latin America and in general, many countries regulate, penally or criminally regulate discourse of hatred. So they can regulate discriminatory discourses or offensive discourses based on race, gender. I don't agree with that opinion. I believe that regulation of expression of hatred brings more problems than solutions. But I could discuss that in another paper. All right, thank you very much indeed to you, to Juan Pablo. Unfortunately, we ran out of time. Thank you for your generosity in your presentations and in sharing your ideas with us, and mostly for leaving a lot of homework for us and many things to reflect on regarding the way to make decisions, constitutional decisions that are the right ones, successful with a virtuous adjective. And to all people that joined us during this week and a half on the sessions, thank you very much. Thank you for your questions. And thank you for holding up with us, keeping up with us, because these were long days and many days actually. And I would also like to thank all people that made this possible, people behind the scenes. It is not just turning on Zoom and having this conference, but we have the effort of many people behind the scenes. I would like to tell you who helped us in the events department. I will try not to miss names, but I thank to all of them. In the events management office, Gabriela, from social communication, Estefania, Gavi, Roberto, from culture departments, legal culture departments, Alejandra, Saul, interpreters that did a marathon work and that also ended up with us. Sometimes we exceeded the time allotted, and yet they kept with us, Cecilia, Gabriela, Roberto, and of course, people that are part of the Supreme Court, Ana Maria for the support, and Gabriela, Areli, and particularly Diana Suarez. She's not an associate, but she really helped us, and without her work, her ongoing work, and without her support, this wouldn't have been possible. So once again, thank you very much. And we hope to see you very soon in another big and participative event such as this one. Have a great afternoon. Thank you. Goodbye.